Hello, everyone. Good morning, good afternoon, or good evening, depending on where and when you're joining us. Welcome to the ESTB Interview, the program that brings to you the key actors of the tax world, the people and institutions that make this field move. Taxation is made of rules, but also, and above all, of people. Understanding who these people are and how they influence the tax system is essential to grasp the dynamics of this field. With this premise, the Escola Superior de Tributação de Brasília, the ESTB, created the ESTB Interview, a space for dialogue with leading figures where we explore their trajectories, ideas, and contributions to the future of taxation. Today's episode addresses a discussion that has become increasingly relevant in contemporary international tax debates: the use of international law arguments to challenge or to constrain global tax reform. In recent years, proposals such as the global minimum tax and other initiatives targeting large multinational enterprises have been met with criticisms grounded on alleged international legal limitations. In many of these debates, concepts such as taxing rights, jurisdictional tax nexus, customary international tax law, permanent establishment, or even legal personality have been invoked as if they were firmly established on legal barriers to reform. Drawing on his article called Why Data Giants Don't Pay Enough Tax, or formerly called Global Tax Reform and Mythical International Law, our guest today, Professor Tarcísio Diniz Magalhães, examines this phenomenon critically. This article argues that many of these purported impediments are, in fact, conceptually under-theorized or legally exaggerated, and that they often operate less as genuine constraints than as discursive obstacles to cooperative reform. So, as I said, our guest today is Professor Tarcísio Diniz Magalhães. He is Associate Professor of International European Tax Law at the University of Antwerp and President of the Antwerp Tax Academy. His research focuses on comparative and international tax law and policy, with particular emphasis on digitalization, sustainability, and global tax governance. So, Professor Magalhães, thank you very much indeed for joining us today. It's a real pleasure to have you here.
Thank you. The pleasure is all mine.
Thanks, Professor. So, to begin, as usually, we start with a personal question. So, Professor, could you tell us a little bit about your academic and your professional journey? So, how did you first become interested in international taxation in general, and what led you more specifically to investigate the role of international legal discourse in contemporary debates on global tax reform?
Yeah, so my trajectory was a little bit different than usual because, well, I was born in Belo Horizonte in Brazil. I grew up in a city nearby called Sete Lagoas. When I was 14, I moved back to Belo Horizonte, and then from there I went to do law, which was something that I was always interested in since I was 12. Which might sound strange, especially coming from a family of engineers and people who liked, the exact sciences and math, and with no lawyers in the family. But it was something that attracted me because I've always been sort of drawn towards questions of justice, questions of rights, of how we organize society. So I pursued this bachelor's degree. In the beginning, I was not entirely sure of which area of the law I was going to end up in. I had this more inclination towards public law because I thought it was a better way to discuss these ideas, but I hadn't had a contact with tax law per se. I was also drawn towards more international aspects of the law because I think growing up after, we started the second globalization phase of the world, I think globalization was a big topic in my life as I was growing up. But at first, my first contact with the topic was mostly with international economic law more generally, so not precisely tax. So I was very interested in trade law. I did some moot courts in that, and then I did an exchange at the University of Wisconsin Law School, where I first got in touch with tax. So when I got there, I was taking courses on international trade and arbitration and intellectual property law because I wanted to understand how the economic and global system works. And then I met someone who in the future would end up being my co-author. At the time, Alison Christians was a professor there. She was an assistant professor, so a young professor. I was a bachelor student. And she had a project on taxation on transnational taxation, which is the idea of influence of external actors in national systems. So I started getting in touch with the topic. I saw tax as the field where questions of distributive justice and social justice would play out more clearly. So that attracted me to that. And then I pursued a master's and a PhD. I have to mention two other professors that had a huge impact on my life. One was Isabel Derzi. I don't need to explain who she is, a huge name in Brazil. She was my supervisor for the bachelor's thesis, the master's, and the PhD, and she was also someone who always had this interest with social justice. And another one was someone that I worked with later, who was Onofre Alves, he was a lawyer for the state. He became the Attorney General. I worked with him for a while, and he also was very much interested in social justice and global governance and tax. So they have had a huge impact in my life as well. So that's what took me there.
Very interesting, Professor. So the reasons that led you to the legal field may explain your actual scholarly approach, maybe. So using that comment to make a link to our conversation, your article starts from the observation that in recent years, international law has been increasingly invoked to oppose or to cast doubt on global tax reform, such as Pillar 2. Not only, but your article touches specifically on Pillar 2. So my question is, why do you think international law has become such a central argumentative resource in these debates? And what does this tell us about the current state of international tax governance?
Right. So I would say the law has always been very central. I think lawyers have always been at the forefront in terms of either pushing the system forward or holding it back. So law was always very, very central. The difference was that so far we had only seen arguments of international law playing out in terms of treaties in the field of international tax, right? So when I did my PhD thesis, which was called A Critical Theory of International Tax Law, I was trying to investigate the foundations, the theoretical basis of the system that we have and the principles that we have and whether they made any sense. And I was trying to do that through a critical perspective. Even if we looked at the most traditional positivist approach to the law, the answer was always that there was nothing beyond treaties, right? So domestic law, so tax law, international tax law is not even that international. This is a joke that all professors say, right? International tax law is not international, it's domestic tax law. And then all you have are these treaties, which are basically contracts between states, right? The reason why I think this whole debate turned to something that so far had never had any impact on the debate or in court cases was because most of the lawyers who are the gatekeepers of the system saw that treaties were not perhaps enough to contain the reform that they didn't want to take place, right? So once you see that the treaty is not enough, and I don't say that as if there's a clear answer there. Of course, there's debate, but there were strong arguments to suggest that treaties would not contain the implementation of the global minimum tax, and either because you could interpret provisions of the treaty in a specific way. The position of the OECD was that the savings clause could accommodate things such as GLOBE. You could reform treaties. You can basically eliminate treaties. They're contracts. You can always end them whenever you want. So what else is left for you to hang on to, right? And I think lawyers went around trying to look for principles or customary international law or customs or things above that would kind of say that we cannot implement this no matter what, right? So that's how we got into this debate, and what what drew me to the debate was that I was coming from this perspective where there's no such thing as customary international law, except for a very minority view. There's no such thing as principles of international taxation. They're binding and mandatory and imposed top down. What we have is voluntary agreements, and then all of a sudden there's all these principles being raised. So my approach to the topic was to contest that and to show, look, there has never been such a thing.
But I don't want to go deeper on this subject, or else we'll completely change our discussion here. But I cannot restrain myself or make some comments on that. The relation between international tax law and international law is not very clear. Normally, international tax lawyers don't see themselves as international lawyers, but paradoxically, in this case, for argument against the international tax reforms, they try to make this link that never was there in the debate. And just for our international audiences, there's a very anecdotal experience in Brazil. The most important manual of international tax law in Brazil, maybe the only one we have in Brazil, is called International Tax Law of Brazil.
Of Brazil, yes.
Of
exactly.
Brazil. Brazilian international tax law. So when I expose that to some colleagues from the international legal domain, they say, well, what do you mean international tax law of Brazil? How can it be? But yeah. It is right. It is right from what it preaches. So from the perspective, it belongs to a Brazilian, Brazilian professor, very influential in Brazilian debate, which is Alberto Xavier or Xavier in Portuguese. For Professor Xavier and for most of the Brazilian legal thinkers, there's no such a thing as an international tax law. So that's the reason why it's the international tax law of Brazil. But okay, I won't go deeper on that. But I don't know if you want to.
Well, no, I would just say, and it's the same in other places. You would see the same expression in the United States where they say U.S. international taxation, right?
Professor Rosen would say the same thing, yeah.
Yeah, and even if we think, Alberto Xavier was one of the most formalistic, and I would say not on the side of changing the system, but keeping the system, and he had that view. So I was also surprised to see that how that changed completely. And in my thesis, I went searching for principles that could kind of push the system towards a better outcome, and I couldn't find them. So if we cannot find principles that would allow the system to promote social justice or to promote taxation in a way that realize these ideals, why is it that the system would have principles that would prevent certain forms of taxation against corporation, right? So that sounded like a contradiction to me.
Yeah, no, it's contradictory. But just to make clear, here in the ESTB, we believe in the link between international tax law and international law, but not in that sense. But normally that's not the case for the traditional doctrinal approach in Brazil. But let's go deeper on your article, and maybe we can go back to this topic. So since we're talking about this contradictory position, maybe this explains a little bit why you use the expression mythical international law. I don't know, you tells us, but as I mentioned, one of the most striking expressions, more impressive expressions of your article is this idea of a mythical international law. So what exactly do you mean by that expression, and how can you distinguish between what would be a genuine role of public international law and the concept that acquired just a rhetorical force in the debate without necessarily corresponding to a binding legal norm?
Right. So so this expression, you see that it doesn't appear in the published version of the paper, and I think the reason was because we realized that the expression could cause some confusion. So when we talk about mythical international law, even in the original version, we were not posing the claim that all international law is mythical, or that there is no relationship between taxation and international law, right? So we fully acknowledge that the relationship exists, but the paper focuses on one specific form of international law, right? And even though I come from this, critical legal studies background that is, not the most formalistic one, not the most traditional one in terms of law, in that paper we're being very formalistic in some parts of it. So one of them is to look at the sources of international law, and the formalistic approach to the source of international law is to say, where do they come from? You go to Article 38 of the Statute of the International Court of Justice. There you're going to find three primary sources and then two secondary sources. The three primary ones, or I like to put them in different terms, is what we could call general international law, and the other one is what we could call conventional international law. So general international law would be general principles and customs, right? So things that states don't actually have to sit together and deliberate for them to arise. Now, conventional international law would be treaties that can be bilateral, multilateral, regional, all sorts of treaties that are basically contracts. So those are the primary source of international law. Beyond that, all we have is secondary sources, which are doctrine. But doctrine has this much lighter impact, right? It's not binding, it's opinions of legal scholars. And then you have decisions by courts, international courts, that only apply to the parties of the case. When we look at this, when we're talking about mythical international law, we're mostly referring to general and not conventional international law. So our paper makes no specific claim about the compatibility of GLOBE with treaties, even though I have my own views there. But it was mostly focusing on the idea that there's no such thing as a general principle that would prohibit or bar GLOBE. There's no custom that all states accept that would bar GLOBE. And of course, there's a way, even from a formalistic perspective, to identify those things. Right? In a field of customary international law, we have this. There's different approaches. So you have one perspective that would, you depart from two basic elements, which is what we call state practice and opinio juris. State practice, which is a external objective element. You have to find something that most states in the world adopt as a practice. And opinio juris is a more internal subjective understanding that they do so not as a matter of tradition, not as a matter of normal practice that they have always been engaged in, but because they believe it is legally binding to do so. So there's these two elements. What is the challenge there with international tax? It's very hard to demonstrate either of them. State practice tends to be a bit easier, but even there, it's very hard if you look around and see how many different definitions of permanent establishment and definitions of source and residence and different source rules and residence rules that countries adopt, different tax systems. Some of them don't even have an income taxation. So it's really hard, I think, to define, to establish state practice. And that's an empirical question, right? How many states do adopt this practice? But when we go to opinio juris, it's even harder because it's subjective. We have to be able to demonstrate that subjectively countries see that as law, as binding, right? And then on top of that, there's all sorts of theories in customary international law. There's theories that would say that there's also something called a persistent objector, somebody that can excuse themselves from a custom because they objected. You have the original objector or the subsequent objector. Then you have a long literature of international law scholars saying that customary international law is something of the past, something that is too hard to establish, that some would claim it's even dead nowadays, right? If you go to a more critical approach, which is the one that I usually take, you're going to see scholars from the Global South raising various suspicions towards customary international law because it is, in a way, undemocratic, right? There's no deliberation, there's no expression of opinion or voting or anything. It just arises from what? From what the legal scholars said or some people said, or right? And when we take those things and apply them to tax, I think it's even more complicated because we have a system that is known to be unfair to many countries. So how can we say that this system, originates customs that bind all countries in the world? So my view is that obviously there's a connection between international tax and international law, but it's very limited. And it would not provide enough support to resist a reform such as GLOBE.
Professor, you've mentioned in the introduction to your answer the ideas of the principles that normally are used in the debate concerning international law. So a central part of your analysis is devoted to examining a series of concepts that critics present as legal constraints on reform. such as the jurisdiction to tax, customary international tax law, or law or tax law, economical alliance, genuine link, permanent establishment, arm's length standard, legal personality, among others. Which ones do you consider the most influential or recurrent concepts today, in your view, and why do they fail to provide a robust legal basis for blocking the implementation of a global minimum tax, for example?
Yeah, so this is interesting because one of the debates that I had at the time when this conversation started was with some lawyers from the United States, very much, against GloBE and saying that there were clear legal barriers to it. And you would see the argumentation shifting. Right? So all these principles or all ideas or concepts that I discuss is because I would find myself arguing with someone and they would say, oh, it violates customary international law. And then, a minute later, they would change and say, no, it violates economic allegiance. And then a minute later, they would say, no, it violates PE, or it violates this, so it felt to me as if it was a endless search for limiting this, which, in itself already raised suspicions in my view that there's no substance in these arguments. So what I try to do is to, let's go through one by one and see the flaws in those arguments. And just before I even get there, if you take, a colleague of mine, Stepan Gacu, who's a associate professor at the University of Rijeka in Croatia. He's written a lot about this topic, right? Principles and, the nexus idea as a principle of international law. I remember reaching out to him because I read his entire paper, and at the end he says, yes, it does. There is something, but it's so difficult to define, and it still leaves so much room for countries to determine what that nexus is going to be, that we have to conclude that these principles or customs or whatever we want to call them are very limited. And then there's this thesis that I don't know if I have to put it here so people can see. It was published recently by Celine Brauman, who's an international lawyer. She was an assistant professor at the University of Ottawa, so she comes from the field of international law, and she wrote an entire thesis on this relationship between customary international law and tax jurisdiction, and her conclusions basically confirm what my analysis had been before, right? So it comes to the end, she says, look, all we can say is that countries are barred from instituting a regime that is completely, she calls it nexusless, right? So no nexus at all. I think we could think of, Belgium trying to tax a Brazilian that never set foot outside Brazil and that does all their economic activities in Brazil and that have absolutely no connection to Belgium, right? So, but the moment there's one connection, then, we're lost, right? We're lost again. It could be residence, it could be source. Those two things can be defined differently. She goes into market jurisdiction as a justification. It says it's compatible with international law. There's nothing that stops it. She even goes into CFC regimes, and she brings some very interesting ideas that we can go into that are particularly relevant for Brazil, because I know this is a strong debate there. But in any case, so I went through all these elements. So customary international law is, very limited to non-existent. Economic allegiance is a theory. If we go back to the history of it, economic allegiance was the theory that for economists, not even lawyers, for economists, that the League of Nations in the 1920s invited to talk about taxation and decide, what do we do with double taxation? They came up with this idea, economic allegiance, right? It's a justification, it's a norm, there's justification or a theory. It's not a legal principle. Genuine link, it's a bit more accepted that you need some form of link, but the issue there is with the genuine, right? What's genuine? And there's going to be all sorts of views on what is genuine, what's sufficient. If you think of PEs are nothing more than a negotiated threshold. They can have many different forms. You can have many different kinds of PEs, as we see with service PEs and agent PEs and constructed PEs, and timelines are different. It's a threshold for the source state to not impose taxation from moment zero, right? For minute one. It's a political decision. Arm's length, it is nothing more than one way to allocate profits. We know there's formulary apportionment. Not that it's something easy to implement, and I have my own views there as well, but arm's length is one way to do that. So when I come down to all of them, I think the one that I feel has a stronger, perhaps, catch, but this is related to a lot of how people assume things are supposed to be, is the one related to legal personality. And on there, I have a new paper, hopefully coming out soon, on the case that is now at the Court of Justice of the European Union, that started here in Belgium against the global minimum tax. And there, I try to make the case that the arguments against GLOBE are all based on a very strict formalist view of separation between entities of a multinational group. And once we get past that, or at least we get past the idea that there's no such thing as a principle that tells us that we have to treat entities of a multinational group as if they were separate fiscally, in terms of property, in terms of money, in terms of assets. There's no such thing that says that the corporation is a legal creature. Then those GLOBE starts to make much more sense as something compatible.
Professor, what I have mentioned gives us the opportunity to go deeper on a debate that is very familiar for us here in the ESTB, which is, for example, among other things, naturalization of some conventions. Yeah. This is particularly important in this international debate. And in your explanation, I could not obliterate the idea that maybe the most striking connection between international tax law and international law is the origin of both. Both are connected to a defense of free trade, international free trade, long distance free trade. In case of international law, it doesn't matter if you believe that international law was born in the 1500s with the discovery of America, with Francisco de Vitoria, because he was suggesting that even the Indians could not constrain the freedom of international freedom of the Spaniards to trade wherever they want, or okay, so you don't attribute to Francisco de Vitoria the origin of international, so you attribute to Hugo Grotius. You're talking about someone that worked for specific, you know this better than myself. So you're talking about a lawyer that worked for an international, one of the first biggest multinationals that the world has ever witnessed it, and also he was arguing that there's such of a natural right to free international trade. So when the international tax debate started, it was the same thing. How can the countries of the world discuss a way of taxation not impeding, not undermining the freedom of international trade? And the same debate reappeared some years ago concerning digital economy. The first striking Congress about digital economy was how can taxation not undermine e-commerce? Yeah. So that's the same thing. That's the same subject since the 1500s. So that's the most striking point. I'm sorry for taking this time, but this connects a lot to what we discuss here in the ESTB, and this connects also with our podcast. We have a podcast that we have issued this a couple of days on Wednesday, and the subject was exactly that: how the international dimension of law has appeared, and we try to make this connection. I don't know if you want to react to that before I go to the other question.
I would just say, you probably already know, but I would just recommend to your students to read the work of Katharina Pister. She's gonna resonate with what you're saying, right? Like the idea that what she's going to call capitalist law, or the legal code of capitalism that has been designed and redesigned, and she's someone that comes from the field of corporate law, not even tax. But I think every tax person should read her work, and she's going to talk about treaties and property rights regimes that were built for capital.
I underscore our recommendation. That's a fantastic book.
Yeah.
But going back to your article, I'm sorry for deterring our debate, but let's go to something very, very technical that you use as a central argument in your article, which is UTPR. So your discussion concerning UTPR, for our audience that don't know what UTPR is, it's one of the unfoldings of the global, the pillar 2. So if you don't know what UTPR, I'm sorry, we have no time for explaining exactly what it is, but it's one of the unfoldings of the pillar 2. And UTPR, in your article, Professor, is particularly important because the rule seems to have concentrated much of the criticism concerning this, what we have been discussing here. So you argue that many objections to UTPR are based on an overly rigid understanding of tax nexus, as you mentioned it, corporate separateness, the ownership of profits. So could you explain why the UTPR became such a focal point of resistance, and how does your article respond to the claim that rules like UTPR somehow violate the basic principles of international law or the corporate law?
Yeah, and so this is very important because UTPR changed in the past years. So the first version of UTPR was less subject to the kind of criticism that the latest version has received. But in any case, very briefly, the basic difference is that the new UTPR basically allows a jurisdiction to tax a company that belongs to a multinational group that is established in its territory, right? So within its jurisdiction. So that country can impose taxation on that company with respect to profits that were undertaxed within a group, anywhere in a group. Why is this more innovative in a way? Because sometimes you're going to have situations where this underprofit or this undertaxed profit is coming from a sister company. So sister company, if we think of a multinational group with three entities, a parent company at the top, 2 subsidiaries at the bottom. The 2 subsidiaries have no shareholding or ownership into each other, right? Direct ownership into each other. They're owned by a parent at the top. The UTPR does allow a country where subsidiary 1 is placed or located to be taxed because subsidiary 2, that is in another jurisdiction, was not taxed enough, right? Where it was not reached to the 15%. But there's a reason for that. Stopping or at least mitigating tax competition and ensuring that there's 15% of tax being imposed on multinational groups requires a system that will allow this game of different countries jumping in and taxing what was not taxed in another jurisdiction, right? The reason why the UTPR changed to the system allowing sister companies to be taxed on each other's undertaxed profit was because we realized that if that was not the case, there would still be some room for tax competition, for tax planning, and the minimum tax would not be reached. Okay, so why do people don't like the idea of 2 sister companies being taxed on each other? They say there's no connection between them at all, except for the fact that they belong to a multinational group. Now, it's not because something was never done that it couldn't be done. So that's, I guess, my first answer to that argument, right? Yeah, it is different. Yeah, it is innovative, but that's because you live in a globalized world and digitalized world where you can place your company and your profits and you can shift things around. And we've seen that otherwise it's really, really impossible to ensure a level playing field. So yeah, it is innovative because tax planning is innovative and tax planning is also creative, right? So the creativity of the tax planning and structuring led to a response that had also or needed also to be creative. Okay, so on what do I base this? So I think the first issue that we have to look at is that people tend to assume that because a multinational group has parts, that they have to be treated separately. That because a sister company is not directly connected to another sister company except for the parent, that I can't shift around attributes between them. But and this doesn't appear fully in this paper that we're discussing, but we will in the next one that is about to be published. So there I go into various theories, including the work of Mariana Pargentler, who's a corporate lawyer from Brazil. Now she's at Harvard Law School. She has written immensely on this. She adopts a comparative law perspective, and she shows that there's nothing that says that we cannot shift around things between entities of a multinational group, right? There's no strong barrier separating the profits and assets from. We could, and up to the moment where we think this is sufficient or is realizing the goals that we want. There's a reason why we separate companies, because it's supposed to create more efficiency. It allows for taking more of risk. If we have, the assets of one company are not going to be affected by another one, but there's nothing that says that I cannot create exceptions to this. So my view is that the corporate veil, and in that paper, I go into international law, investment law, corporate law to try to find anything that resembles a strict corporate veil point of view, and I cannot find anything there as well. So my view is that it should be seen as a spectrum. You could have unitary taxation at the extreme, you can have strict separability at the other extreme, and then there's a whole middle that you can place different regimes in, right? So I think Globe kind of falls in between there. It's not a full unitary system, but it's also not a fully strict system that will never consider that companies that belong to the same multinational group could be somehow affected by each other's behaviors. Sometimes you're going to see a lot of people trying to make an international law case out of this by referring to a 1970s International Court of Justice case called Barcelona Traction. But in that paper that we're discussing, I go into it and I show how this case not only is old, not only had nothing to do with taxation. So people tend to extract a strong corporate law principle there. The judges have never said that such a principle exists. They analyzed the domestic law of the parties involved in a case. And on top of everything, there was a much recent case called Diallo, which was decided in 2007, where the International Court of Justice explicitly said that corporate rights are only found in either domestic law or specific treaties, such as investment treaties, right? So beyond that, there's no principle that tells me or that tells countries that they cannot adopt a more transparent approach to multinational groups or a unitary taxation approach, or that they cannot tax a company that is within their territory with respect to under-taxed profits somewhere else because they belong to the same economic group.
See, Professor. So unfortunately, we've got to go to the end of your article because we have some time constraints here. So your conclusion calls for a shift away from what you described as the mythological international law and towards the cooperative problem solving, as you said. So in practical terms, what would that shift require from scholars, policymakers, or international institutions? And what do you see as the main institutional challenges for building workable and legitimate forms of global tax cooperation in the years ahead?
Yeah, I think that's a question that connects to recent changes that we've been seeing in terms of where decision making is taking place, whether it's going to be at the OECD level or the UN level, and who are those that can stand in a way of reform, right? So I do think that there's a lot of interest, of course, financial interests of many, that Globe doesn't succeed. That's very clear. It's a regime that will ensure that some of the companies, some of the most profitable companies in the world that have not paid their fair share of taxes, they have consistently avoided taxes sometimes to the level of almost zero, that they would be paying at least 15%, which is not a crazy idea. But so of course there's a lot of interest there, and the interests are not only private, but also from certain states, right? So we have the United States as the one that is most affected by this kind of regime, pushing strongly against it. Looking at recent events, I think those power dynamics will be the most difficult things to overcome. This is something I wrote in my thesis. I think coming from a critical legal perspective and legal realism, power is something that we don't take lightly, right? Like it's something that we really need to consider in terms of in how the law is interpreted, applied, enforced, designed, and power is something that can never be fully eliminated. What can we do with power? We can redistribute it better, right? We can create mechanisms for checks and balances, but we can't really fully eliminate power. The UN, the recent discussion of the UN, which was something that the developing countries try to push forward, is a way to take some power away from OECD countries, take it also away from powerful interests that dominate over the OECD. So those, we're going to have to see how that plays out. I personally think that the UN has a lot to contribute there, but we need also regional structures. Have a close colleague, Afton Titus from South Africa, from the University of from Cape Town, the University of Cape Town. She has written a lot about this, and I would immensely recommend her work on how regionalism in Africa could create these platforms to redistribute power more equally. So I think the challenges will be there. I think there's a challenge also for tax scholars. I think tax scholars need to be more aware of the ideological underpinnings of their positions. We also have to be more aware of the influence of conflict of interest and financial, influence and money and power over how scholars, design their position. So I think there's a lot there to unpack, but power has to be taken seriously.
Professor, you already has touched this subject in this last answer, but going beyond the critiques and thinking about academics, practitioners, and public officials like myself who are following these debates, what more specific message to this audience would you leave about how international legal arguments should be approached in the context of the global tax reform?
Yeah, so I would say legal arguments are not just technical arguments. They're never going to be only technical arguments. And it's easy to get sucked into the idea, especially international tax. If you go read about transfer pricing, it's so technical, it's highly technical. You have, 5 different methods or even more depending on a country, and they require a lot of economic analysis and little issues here. So I think we need to always remind ourselves that we need to take a step back and look at what is it that these rules are doing and what is it these legal arguments are doing, and they will be distributing things to people, to companies, to states. They will be distributing money, prestige, power, status, all sorts of, right? Like at the basis of law, there's a distributional question that we can't avoid. And I think when we get sucked into the idea of technicality, we just think, well, we're just applying a transfer pricing method, we're applying a rule, or applying a legal argument. But those legal arguments, those rules will have immense consequences in terms of who wins, who loses, who becomes richer, who becomes poorer. And I think, what attracted me into tax, to the field of tax, was that I think there it's very clear the connection between, money, resources, wealth, and how we share those things collectively.
Indeed, I could not agree more with your last sentence. So, Professor Magalhães, unfortunately, we have to stop our conversation right now, but I would like to thank you very much indeed for your time, for sharing your insights with us today. It was a real pleasure discuss with you all these subjects and hear a perspective on such a timely and intellectually rich topic. So thank you so much, Professor.
Again, it was all my pleasure. Thank you so much.
And going back to our audience, thank you also for joining us today. For those interested in this discussion, I highly recommend reading Professor Tarcísio's article, Why Data Giants Don't Pay Enough Taxes, which serves as the basis for today's interview. We'll leave the link in this chat. If I'm not mistaken, it's on the Social Science Research Network, is it, Professor? So yeah. We'll keep the link here in the chat. Don't forget to like this video, to subscribe to the channel, and to activate notifications so you won't miss the next episode of the ESTB Interview, which will take place in 2 weeks. Until next time, bye-bye.